All right. Hello and welcome to our podcast about education and the First Amendment, generously hosted by American Constitution Society at Georgia State University. My name is Cody Choi, a 3L at Georgia State University College of Law, and I am joined by two amazing guests, Professor Craig Goodmark and Professor Gerald Weber. They co-teach the Survey of the First Amendment course here at Georgia State University College of Law, and both have extensive backgrounds in litigating First Amendment issues. So, professors, thank you for being here today. And could you give us a little bit about yourselves?
Sure. My name is Gerald Weber. I've been a lawyer for 30 plus years, was legal director for the Georgia ACLU for about 17 years, and now I kind of wear a lot of hats. I am senior counsel at the Southern Center for Human Rights, have my own kind of civil rights ACLU-ish practice, and then teach at Georgia State Law School and Emory Law School.
My name is Craig Goodmark. I'm an education civil rights attorney. I've been practicing education civil rights for over 20 years now. The majority of my practice involves representing students, teachers, or families involved in public school proceedings with a focus on civil rights and the civil rights of those students and teachers. I've handled over the years several impact litigation matters involving the Metro Atlanta area, as well as a couple of class cases impacting the entire state of Georgia. We're happy to be here.
All right, thank you. And how did you both come to know each other and teach this class together?
Oh, it's an interesting question.
I'll let Craig tell that one.
Yeah. So I was in law school at the University of Florida, and I participated in the inaugural Team Child program at University of Florida Law School, representing juveniles. Down there, I knew that I wanted to practice civil rights law, and I sent my application to the legal director at the ACLU of Georgia, who happened to be Gerald Weber at the time. I believe my application contained the references of lifeguard, baseball camp counselor, and a law clerk in my dad's law firm. And for some reason, Jerry asked me to be an intern at the ACLU of Georgia, and we have known each other and been working together since 1998.
Yeah, it was curious. First college baseball player to apply to the ACLU while I was there, and I think the last.
Yeah, I think that's right.
Yeah.
That's a big title to hold. So yeah, we're here to talk about the current state of the First Amendment and its intersection with education. The different interests of education, the First Amendment tend to clash with each other from time to time, but kind of seem to be at odds today in particular. So with that, I kind of wanted to start off the conversation with sort of a general question, compound question at that. What kind of First Amendment protections do students and teachers currently have in public schools, and how do they differ, if at all?
Well, I'll hit the students, and then Craig can probably hit the teachers. Students, since the Tinker case back in the 60s, have had pretty broad First Amendment rights, especially if it's their own speech. It's not associated with a school newspaper or some school activity. And basically what the courts have said is you have to show a material and substantial disruption. And there, Ms. Tinker was just wearing a black armband to protest the Vietnam War, and the court said that standard wasn't met. Slightly lower standard if it's a school-sponsored activity, and exactly what is school-sponsored and what is not is kind of up for debate. But when that standard applies, it's a little bit more deferential to the schools.
I think teachers probably, and if we're talking about teachers, we're talking about them in the context of their public employment. So we're talking about public school teachers while they are operating as teachers, not in their private capacity, not when they're on vacation, but as in their capacity as a teacher, enjoy less First Amendment protection. Particularly when you're talking about their curricular activities, meaning how they plan their classroom, how they provide instruction. And then we should make that additional distinction between teachers that teach in kindergarten through 12th grade, as opposed to higher education and professors and those educators who enjoy what's called more academic freedom. Since the Supreme Court case, that was about 15 years ago now, Garcetti, public employees have enjoyed less First Amendment protections and have been limited to enjoying First Amendment protections only for that speech that's not within the context of their employment. And in the 11th Circuit here in Georgia, where we live, that's been interpreted very broadly. And in fact, Jerry and I have handled now 2 cases where we have found the limits of Garcetti, one in a retaliation context of somebody participating in a public school meeting, the other for a union president who was speaking on the steps of the Capitol.
Yeah, and the Supreme Court's even more recently said that even a football coach, who's praying on the field right after the game with some of the players is not acting as a coach, but as an individual. So we're hopeful that that's a sign that teachers are going to have more and more free speech rights as the law progresses.
Okay, and specifically on the student note, to what extent would you say public school students have a right to receive information?
That's really up in the air. I mean, the one case that the Supreme Court has had that's kind of directly hit that issue was whether a school district that decided to remove books from the school library violated students' free speech rights. And it was a very, very close opinion, what's called a plurality opinion, where there's no real majority opinion. But the school board decided to remove the books because some of them were anti-American or just plain filthy, was the standard of the school board. And the Supreme Court said that wasn't a sufficient standard, and so the students won there. But in general, under the First Amendment, there's very limited rights to receive information, but at least the door has been opened to students' right to receive information, and that's being developed so much now in these divisive concept laws that we'll be talking about in a little bit.
And I know that it was touched on briefly earlier, but do students and teachers enjoy the same protections at public colleges and universities?
So teachers, it would be absolutely different. And we've actually seen that distinction play out very recently in some of these divisive concepts lawsuits. Because of the academic freedom that professors enjoy and their difference in what has been determined the purpose and policy of academia, and that's to develop learning and to research, they enjoy more protection than a K through 12 teacher whose purpose and policy is to impart wisdom on the students in which they're teaching. The other piece of that is that the tenure procedures that attach to professors are more robust than those that would be applying to teachers, particularly here in the South and Georgia. And so professors enjoy more protection because of their role as professor in academia, as opposed to K through 12 teachers.
And kind of a similar expansion of rights for university students. Hazelwood does not apply, the one that's about school-sponsored speech, and the Tinker Standard doesn't apply. So in general, they're regarded as having pretty large First Amendment rights that may vary depending upon the particular fact pattern, but certainly near akin to any person out on the street.
And again, that would be about the distinction about who we're talking about. Are we talking about fifth graders, or are we talking about college, university students who are then also being part of that research dynamic or that development of knowledge that is attributed to higher learning?
And that's a great kind of general segue to kind of dive in a little deeper into what is certainly a hot topic with education now, which is divisive concepts. So can you tell us a little bit about what divisive concepts are?
Sure. So I had to go back and look. I've talked about this in the past, and I had to refresh my memory as to how this all began. But what is divisive concepts is one label for what has been called the anti-critical race movement, which was a construct, an invention of a conservative journalist named Christopher Rufo, who called on the federal government to ban critical race theory, a concept that has been created and then amplified across the country, but isn't generally considered a true theory. It's an idea that was part of a certain piece of research, but it was grabbed onto by Christopher Rufo, and then subsequently by President Trump, who issued an executive order that laid out what their view of what the government's view of what divisive concepts were. That executive order ordered that divisive concepts be banned. The idea that American systems are fundamentally racist would be one of the concepts that's developed in the critical race theories, as they're called. That one race is inherently superior to another divisive concept. There are several, and then from President Trump's executive order, you see a proliferation of rules, policies, declarations, proclamations all across the country in many different contexts, mostly, predominantly in the school context because of the way it applies, but not only in schools, where school boards, state boards of education, state legislatures are all passing these ideas or rules limiting or banning altogether the instruction or inclusion of critical race theory. The issue itself becomes a centerpiece of an election where banning CRT or banning divisive concepts becomes a political issue that's used by both sides in order to have their candidate elected.
And the problem is kind of on the ground, once these laws pass, what do they mean? Kind of to your question. And even to use some of the language from the Georgia law, fundamentally racist. Is a teacher allowed to talk about what's called the 3/5 compromise that had diminished recognition of Black persons under the terms of the Constitution? One might say, well, that is essentially saying that the United States is fundamentally racist because its founding document literally accounts for a Black person as less than a white person, and therefore I can't teach it. And other teachers might say, well, I'm just talking about the Constitution. That surely can't be prohibited. The words of the Constitution. And so the difficulty for teachers and ultimately for students, because they get less information, is that teachers tend to be risk averse and they don't want to get fired. They don't want to get disciplined. And so if they are left to guess in a very political, divisive environment, they will not teach subjects. And that's what's ultimately we've seen on the ground is what's happening.
And this movement has kind of encompassed more than just like critical race theory, right? It's also included, don't say gay and sensitive, controversial topics, as they call it.
So it seems as if the whistle had been blown or the bell had been rung, and the idea that it's okay or we are able to censor what's being taught and what's being read in public schools, it has passed some sort of threshold. And so now we see in Florida, we have the Don't Say Gay bill. We have similar legislation here in Georgia. You see, kind of the Parents' Bill of Rights start to develop, where we're injecting outsiders into the pedagogical process. We're letting parents and the community into what used to be a pretty sacred space, which was the classroom. I can remember, it wasn't that long ago that teachers didn't want anybody in their classroom. They didn't want cameras in their classroom. They don't want people telling them how to teach. And administrators would carry that ball for them. They wouldn't let people come in, and they would try to insulate the classroom because it is such a sensitive environment. I mean, you're really trying to do what is, at least as I see it, my mother was a public school teacher, one of the hardest things that can be done, which is to teach somebody, to impart knowledge, to give them information and have that be developed into something. You think about how you teach somebody to read. It's not an easy task. And so to allow parents, community members, politicians, outsiders, or possibly agitators into that dynamic is a problem. And so you've seen it, and we've seen it very clearly here in Georgia and in Metro Atlanta, what the impact of that has been in it. And as I've seen it, it's been very disruptive.
Yeah, and they say, all politics is local. Now, really, all politics is national. And so these issues are on the national stage. And what we're losing in this process is the expertise of the administrators and the teachers on the ground that know their students, that know their community. And now they're governed by standards from above that may be contrary to the interests of the students and the families.
Yeah, it's a good point, and it's a really clear example of how a national agenda would affect somebody locally. People taking their marching orders from somebody other than the people that elected them.
Yep.
As if you look in some of our metro Atlanta counties, the constituency is way more diverse. If they all voted, would never allow this type of policy, this type of censorship or limitation on discussions about issue of race in America being fundamentally racist to proliferate. And yet, you do see it happening from the top down.
And for our listeners, can you kind of expand on what is usually included in like Parents' Bill of Rights, and also like what the relationship is specifically to like divisive concepts?
Sure. And I can only speak for our Georgia Parents' Bill of Rights because I know that they exist in many different ways. But the Georgia Parent Bill of Rights that was passed by our legislature 2 years ago essentially says that parents have the right to raise their children, and that schools in their policies, rules, procedures, and actions cannot inhibit or impinge upon the right to bring up their children with regard to morality, with regard to, I'm going to blank on the other two, but with regard to sensitive concepts and sexuality. And it's usually brought along with, the idea that, sexual content in books and in materials and the curricular materials shouldn't be there, is inappropriate. And that's one of the ways in that we've seen it over time. What's interesting to me about that is that we already had a rule about, how a school can evaluate a book for its sexual content and determine its appropriateness. And, that's kind of why we see the librarians right now in Georgia up in arms, is because librarians have been operating under a rule where, okay, if you have a problem with the book, you think there's sexual content in it that's not appropriate for the elementary school, we know how to deal with that. But they've essentially jumped that rule, created what is, a more direct avenue for parents to complain, and really, just, amped up the consequences to a place where librarians are leaving. They're like, I don't want any part of this fight. I represent teachers and administrators. I've already seen administrators resign rather than get involved in a fight like that. And they just say, no, I'm washing my hands with that because there's no win. There's no way for me to get out of this without either me getting dragged into a culture war or me losing my job. And so it's really a problem.
Yeah, and one thing to think about, Georgia's law does not apply at the university level. And that was because of a lot of advocacy of university student groups. They went down to the Capitol. They made their views known. Other states do have these same kind of laws applying at the university level. And, Georgia is at risk. The fact that it didn't happen the first time doesn't mean it won't happen in 2025 or 2026.
And in fact, that's one of the primary distinctions between what's happened in Florida and what's happened in Georgia. They have litigation in Florida that's addressing these issues, and because Florida broadened out their censorship rules and their limitations on, or their bans on divisive concepts, they were able to, the people that challenged the law were able to maintain that challenge because they carried over into a place where academic freedom really wins the day. Here in Georgia, we don't have that, and I think it should be a warning to legislators here to say, if you carry into the higher ed, which is probably a more friendly environment for professors, right? You could suffer the same consequence.
And kind of, well, of course, being at Georgia State University, does Georgia have any, besides the Parent Bill of Rights, do they have any other thing that's really addressing controversial topics?
At the higher ed level?
Just K through 12.
K through 12, controversial topics. The divisive concepts law is the only statewide law. Now, a place like Cobb County, where we do have active litigation, is the primary place where we've seen the kind of building out of the statute into the policies in a very aggressive way. In Cobb County, they have what's called a controversial issues rule, which was, interestingly, an old rule. And it was a rule that was probably about a case that Jerry did but 25 years ago with regards to evolution and teaching creationism in schools. But that controversial issues rule was then amended after the divisive concept statute was created to include language that dealt with sensitive topics and controversial issues, such as divisive concepts, where they incorporated the divisive concepts definition into the rule. And so you have this, what is now a wider ban or a wider prohibition on the things that you can and can't do in the classroom. And directly related to that would be the consequences that educators suffer or are threatened with if they do violate that rule.
Yeah, and one of the big constitutional issues with a lot of these standards is vagueness. For example, the policy in Cobb County uses the word controversial, but doesn't explain what it means. And so and we'll talk about the case in just a little bit, but as the case is developed, principals were on the stand saying, we're asking them what does controversial mean? For example, the cause of the Civil War is something about which some people have different views. Is it about slavery or is it about something else? And if parents have different views, is that controversial? And she said, yes, it is. Anytime parents disagree, it's controversial. And just think about the breadth of education that we have and the amount of disagreement there is among parents about what particular theories of science, history especially, current events would all potentially be off the table because parents have different views. And that is controversial, according to the administrators in Cobb County.
And so difficult for a teacher to navigate, because how are we supposed to know what people's views on these things are? Are we supposed to take a poll, at the beginning of the school year and ask all these families, please come tell us your most sensitive, viewpoints on religion and on sexuality and on race? That's an impossible ask. And so to inject into the standard what two people believe if they agree, and if they do not agree, then it's controversial, really throws the rule up into chaos. And this is what we're left with, especially in a place like Cobb County.
And even if you had that survey, then some student raises their hand and talks about something, and the teacher's answer is, I'm not allowed to speak about that. And how does that build the relationship between teachers and students? The students' kind of thirst for knowledge is squelched at that moment.
It really is a very negative impact. I was reading today, and one of the ideas of the limits of the divisive concepts or the limitations on students is in a place like AP classes, where you're talking about, say, for example, AP history. Well, AP classes are subject to an AP test that's created by somebody that's not in the school district. It's in a company. It's usually, I think it's by College Board or by Kaplan or by somebody else who creates this AP test. If the students ask a question about the Three-Fifths Compromise, and they need to have an understanding of it sufficient to get college credit for their answer, but the teacher is limited in their response to, I can't talk about that right now. Well, how is the student supposed to be prepared for that test? And in fact, in Arkansas, you see there's a lawsuit that was filed by students with respect to this exact issue of taking the AP test, and that the way in which their statute, and I believe it's probably a local policy, had been created would prevent them, from being able to take this test to gain that college credit. Students get that college credit because that's less money they have to pay to college. So there's a real financial interest in students obtaining AP credit, right? And now they can't do this because of this rule. So we actually see a damage there, a very real, damage. And it's one of the things that we think about when you look at these cases. People want to know, but what's the harm? Well, here you go. In Arkansas, students trying to take AP classes can't get AP credit. And now they're going to have to pay for an additional credit or 3 credits in college. There's a financial harm.
And I know you both kind of mentioned it, but could you tell us a little bit about the Cobb County litigation that's happening?
Sure. And we should say the Cobb County litigation exists in a few different forms because of the way that the case arose, but we'll start with kind of the beginning, which is the basic facts. It was March of last year. A 5th grade gifted teacher named Katie Rinderly had a book selection exercise where she allowed her children of her 5th grade gifted class to select a book to read. Among the book choices was a book called My Shadow is Purple. The students voted on the books. They selected the book. Because there was a split in the vote, she had them re-vote. They selected the book again, and so she read the book. That was on a Wednesday. On Friday, Ms. Rinderly was brought down to the administrator's office and told that parents have complained about this book. By the next Monday, Ms. Rinderly is placed on leave, and there's what's called an investigation being opened into her violation of the divisive concepts rules, what she's told. She is now out on leave, and Cobb County investigates what happens. And we come to learn later on that there is a parent that has sent an email, and she has communicated with other parents trying to rally support for her position. And in this memo, she states, queer is a divisive concept. And that's what it says in the email, or something close to that. And so obviously that's her view, and she's outside of the classroom, and she believes that this book, My Shadow is Purple, which is a book about gender beyond the binary. It portrays a student who on the cover is wearing a skirt and a shirt, is a gender identifying boy, but is speaking through the book about how they don't know if they are actually, their shadow is blue or their shadow is pink. And in exploring, or as the book evolves or continues, finds that there's all kinds of different shadows, and the boy is the child is accepted because we all have different colors of shadows. And the child ends the book and says, "My shadow is purple," and so that's the book. Perfectly appropriate book for fifth grade. It's appropriate on the literary level, right? And it's appropriate as a picture book. And a book that, go ahead.
And the district is, part of what students are supposed to receive is training, instruction about inclusiveness that's specifically articulated in their policies, and to limit or eliminate bullying. And that was part of Katie's motivation in doing this. She was a student from Cobb County herself. She had been in the school system for 17 years by the time she was terminated.
Add on to it that the book was actually purchased at the school's book fair just a few weeks before in February. And among the other books that were being put out by the Scholastic America, who puts on the book fairs, on school property with the permission of the administration, she purchases that book at the book fair and then places the book in her classroom. Nobody complains about the purchase. Nobody complains about the vote. Only after a parent complains to the administration is she placed on leave and investigated for violation of the divisive concepts rule. And we then find out that what the school district, quote, meant was she had violated the controversial issues rule, which is actually the title of the policy. And from there, the investigation broadens out. There's a few ins and outs on claims that Ms. Rinderly is dishonest and claim that the students were being harassed. All of these don't play out at hearing, but the core of the issue is that she has allowed this book to be read in her classroom to fifth grade students. A parent believed that queer is divisive, and the district took action on that statement.
And ultimately, there was a tribunal of former educators selected by the school district, with a lawyer overseeing the process, again selected by the school district, who found that she should not be terminated. And they presented that recommendation to the school board. The school board, without even sort of reviewing the transcript, reviewing the evidence, just kind of on the fly at a board meeting, overruled that tribunal's recommendation and terminated her.
And what was really a very political proceeding. We were there that night. It was obviously charged atmosphere. The Cobb County School Board, the Cobb County Board of Education is a very divided political animal right now. The people that spoke were speaking at the very extremes of our political spectrum, and what I, as a firsthand witness of it, believed was just a really a concerning display of hatred and negativity, just really an ugly scene. And in that context, that political context, the board then took this action without even reviewing the transcript of terminating Ms. Rinderly. So Ms. Rinderly pursued her appeals through the State Board of Education. And at the same time, Ms. Rinderly obtained counsel, and Jerry and I represent Katie Rinderly along with lawyers at the Southern Poverty Law Center and lawyers from the National Education Association, because she is a member of the Georgia Association of Educators, which is our teachers organization here in Georgia. We represented her, and we affirmatively filed a lawsuit in federal court raising Ms. Rinderly's all her available claims, including that this statute or the rule that she was being terminated under, as Jerry had mentioned, was vague. We don't know what the limits of that rule are. Also raising claims that Ms. Rinderly was being treated differently because of her protection of students who are identifying as non-binary, and also raising claims under Title IX for the unequal treatment of students based on gender and race and sex. Excuse me. So that case is currently pending, an affirmative case, and so all of this, Cobb County activity, and there's more that goes on in Cobb County that we're not involved in with respect to the way that they
a redistricting battle over the lines for the school board, many other things. There's probably likely litigation about even the process by which they've allowed citizens to comment at the board meetings to try to steer all the commentors to the view of the majority of the school board. So it's really politics gone wrong, and I think they've lost sight of students, then they've lost sight of the families in Cobb County at this point.
And it all dovetails into what the legislature had done 2 years ago when they created a divisive concept statute. They passed that law at the end of the session in April. It was enacted in July. In November, a litigation team that Jerry and I are involved in sent the governor a letter and said, we intend to file a lawsuit with respect to these divisive concept statute because we believe that it's unconstitutional. We can see the impact of that unconstitutional law in Cobb County and in Katie Rinderly's case. Those vague, broad, and unknowable concepts in 1084, which is the divisive concepts law, exist in the same, almost verbatim, in Cobb County's policies. And while Katie Rinderly's case wasn't necessarily about race, the censorship that was being imposed upon her and on all the teachers in that school district is the same type of censorship. And it's that censorship that we're talking about. It kind of goes back to Christopher Rufo and the critical race theory, where we're trying to eliminate one swath of very necessary and important information for students simply because we don't like it. And those kind of judgments, those kind of that type of censorship is dangerous, and that's what we're trying to impact on right now.
And it's robbing parents of an education that they want for their students. So yes, there are some parents who don't want certain views being expressed, but there are other parents who want those views being discussed. Who want they may have a child who has questions about their gender identity, and they want that explored in class. They are robbed of that opportunity. They are prohibited by state law from having their children who are struggling have the kind of support that they need from their education system.
And this is a kind of question that I was thinking about just now, but states often have kind of a variation of like the First Amendment that can either usually grant more protections. Would you expect the Georgia Constitution to kind of give a better outcome on these kinds of issues than the?
The Georgia's equivalent of the First Amendment is broader in a number of ways that may have an impact on these kinds of statutes and school district policies. There's also a freedom of conscience provision in the Georgia Constitution that has been largely uninterpreted, but seems to speak to some of the issues that are raised in this litigation too. So it may play out in the future. We'll see.
Okay, well, and kind of speaking of the future, which is a perfect segue, what do you both think the future holds for divisive concepts and kind of this litigation that's pending?
I mean, who knows what the courts are going to do? It's going to take a long time for that all to play out. But at the same time that things are playing out in the court system, things are playing out in schools, and things are playing out in school board meetings. I don't think anybody wants yelling and screaming at school board meetings. I don't think anybody really, in their heart of hearts, wants a view of history that is so slanted that we cannot even talk about, for example, the Civil War, that we cannot talk about race discrimination, and that we cannot talk about gender identity issues. And so that may change on a grassroots level where boards change their constituency. For example, in Cobb County, one vote different, and there would be a different reaction to a lot of these policies, probably a repeal of all these policies. And so, I think that the question is more how it's going to play out in the real world as opposed to how it's going to play out in the courts. The courts are a vehicle for kind of showing the problems with these laws, and in some areas that those laws may be enjoined, but ultimately I think it's a collective consciousness that says this is bad for our kids.
So if you're looking at the courts, we haven't seen a consensus. There hasn't been a clear theory that's been adopted. In Florida, there was a strong showing by the litigants there and against the CRT bill. In Arkansas, similar. There's cases in Virginia. There's cases in Oklahoma. There's cases around this country. You can go to the internet and track the anti-CRT activity. And today I looked on it before I got on this podcast, and it was up to 803 official acts by a board or some legislative entity. And so I think we're going to continue to see this until it reaches some critical point. I don't see that we're going to get a national consensus. I don't see that our leadership nationally is even in the position to do that. One of the things that we know about school issues is that they are very local. And that means in Georgia, there's 152 different views because there's 152 different school boards right now that can pass a policy. And, while some of those school boards say we're not taking, any real part in this debate, there are others that say we are going to carry this water as far and as long as we need to in order to carry out whatever agenda somebody else is feeding them as the agenda of the day. But I think that, one of the things when you evaluate these cases is consistent is that the language is unclear. No one, I've looked at a bunch of these, no one has passed any kind of rule that is able to be implemented with any certainty. And one of the things that we learn, in very early on when we're taking constitutional law is that when you don't have that certainty, you're going to give yourself problems, right? There's going to be litigation. And while it doesn't have to be a perfect policy, especially at that level, it's got to be better than what, they've been developing so far. And, don't teach controversial issues, and where controversial in the community means anytime two people disagree, is just a recipe for disaster, right? And so I think we're going to see that continue. And because we don't have the ability to issue any kind of consensus as to what it is they're talking about, what it is they want to limit, that doesn't impinge on somebody's individual rights, I think that's what you're going to have is just this kind of cacophony and chaos.
And it's a recipe for disaster, to use your term, in terms of the education that students receive. But kind of more broadly, it's how kids deal with conflict. If conflict is removed from the schools, the kind of conflict that we're talking about is different views, what kind of adults are we raising down the line?
And with that point too, I was kind of thinking, what kind of wiggle room would you say like boards, local boards, even have to kind of develop policies under like the broader statute of the umbrella, and kind of what kind of hope do teachers and students have?
So I'll take the first part of that question is that it says that they have to pass a policy. HIT 1084 says each school district has to pass a policy. So they have to have the policy. The statute also said that the State Department of Education had to create a model policy. It doesn't say that they have to use the model policy, but what we've seen is that most of the school boards, we had done an open records request with Southern Poverty Law Center and collected lots of correspondence and emails and information about how this all went down. And most school districts just took the state board's policy and implemented it. So that's I think as good an answer as you have, is they're just going to do the minimum of what they have to do and kind of hold their nose. For some school districts who politically are opposed to this, we haven't seen much activity, enforcement of the policy. For school districts that are politically in favor of it, we hear that teachers' speech is being chilled, that teachers are afraid for their jobs, that administrators are quitting, and librarians are up in arms. And so that's what we've seen.
Yeah, I think that folks at the top, the school board members in districts that are vocal opponents of this law, I think are sending a message that the law is not something that will lead to teachers' terminations or discipline. And so those teachers are feeling more able to do what they think is best for their kids. Other districts where the folks at the top are either running scared about the policy, or they are very much in favor of the divisive concepts law, are reading it very broadly. And we've seen kind of the information from some school districts where part of the core curriculum in Georgia is that you have to talk about the Civil War. But some of the teachers are being told that if they do that at their peril. So what kind of box are we putting our teachers in? What kind of information are we ultimately letting our students see? And what are we not letting them see?
And if you back that out a little further, what's the impact on Georgia and able to recruit teachers? Right? It's not better in Florida. So really, we're talking about regionally. Is the Southeast going to be able to keep the 22-year-old, 23-year-old student that graduates from Education College at University of Georgia or at University of Tennessee, when they know that the job they take is only good for up until the point when they start talking about slavery? It really is a problem, and it's one of the reasons when people ask me what they say, this is just bad for education. Because when you lose good teachers, you can look at Georgia where they rank. It's not in the top third, right? As far as public education goes, we pay the least. We attribute the least amount of money per capita. We're in the bottom third, least amount of money per student. Excuse me. We don't put a lot of money into our public education system. Now we don't protect our teachers the way that we used to with respect to tenure rights. And now we've just created an even scarier threshold or impediment to keeping your job, which is we can fire you for whatever we want to fire you for, because you just talked about the fact that there's 2 + 2 is 22, and that's controversial because two people disagree about that. So I think it's bad for Georgia, certainly bad for Georgia's public education system.
Yeah, I can kind of imagine that there would be, just thinking like there's got to be a lot of things that the students are going to see outside of the classroom that are going to confuse them. Like, I kind of just wonder how, national holidays are treated in the backgrounds of them, like MLK Day, Black History Month, things like that, or even just monuments that they might run into. I can imagine that'd be very confusing, and just wondering what is that, and you can't talk about it from people who are educators.
Yeah, I think that's a problem. It is, what kind of adults are we going to raise when they have these gaps in their not only knowledge, but their thinking process, because so much is off limits.
And in a way, it kind of seems like it's almost moving some of education to privatization, just kind of having other people outside, relying on other people besides educators to kind of teach these core topics. So, and I'm kind of wondering what the implications are if a teacher wanted to, a K through 12 teacher wanted to privately tutor students outside. It's not on school grounds, but
yeah, I mean, it's interesting. Georgia's law, as many of these laws, it is unclear the reach of activities that the teacher is engaged in that are covered. And Georgia's law, for example, covers guest speakers. So you go to a high school, you're subject to that divisive concepts law. If you're a vendor who's providing books, you're subject to that law. If you're out in the parking lot as a teacher, that conversation that you have with your student who is having questions about their gender identity and is thinking about suicide is covered by that law. And most of the laws are sufficiently ambiguous that they are far, far beyond what is curricular, and touch on student teaching, but even more peripheral things like you run into your student in the grocery store.
And as you raised privatization, there was a statute proposed that would limit what could be discussed in private schools, alongside a statute which would provide families the full-time equivalency for a student to pay for their student to go to private school. And so I think you are absolutely seeing a preference, right? A move towards privatization in Georgia's Georgia's education system. Mostly I feel like what you're seeing is a political attack on public education, rooted in, really nothing more than just wanting to win elections. Has nothing to do with educational policy. The results that you get from public high schools on standardized tests and, the ability to create literate, students at third grade are not that different, not different enough to justify the attack. And so this is more about politics than it is about law, even though we're here talking about the law today. This is really a kind of a political ambush.
Yeah, and beyond politics, it's kind of whitewashing racism and trying to pretend like racism doesn't exist, has not existed. How is a teacher in a majority black school or any school with black students going to be able to help them cope with law enforcement, unjustified shootings and killings of persons on the street who are black? The kids are thinking about it. The kids are struggling with it, and the teachers need to be there for them and to help them through that thought process.
And to an earlier point that I was thinking about, I didn't bring up at the time, but now I wish I had. But when it comes to school boards maybe having the option of just non-enforcement as a way to kind of work around this, I know Georgia sometimes has, with other policies, kind of created like task forces to kind of force enforcement. Do you think that would kind of be something that might happen if they try to exercise that?
So one of the things that our Georgia Constitution does is empower school boards locally to operate and manage their school districts. And so it's pretty difficult for the state to impose their will. It's very similar to the way that the federal Department of Education operates for the local states. Like they provide, training and guidance and can provide some funding incentives, but they can't really tell them what to do. And that's how these states have all gone rogue, right? Similar here in Georgia. The Georgia Department of Education can't control 152 school districts the way that you would think they could. And it plays out in a lot of different capacities and in different disciplines. But the idea that they would somehow be able to bring a district like a metro district to task for not enforcing their 1084 policy is probably cabined by that constitutional authority that local boards of education have. So many cases that we've handled against school districts and school boards relate back to a defense that the school district will put in front of a judge that says, look, what you're really arguing about is the way we operate and manage our school district. And we're the local board of education, and the Georgia Constitution tells us that we have the sole authority to do that. And so your argument should fail. And there are judges that have said, yes, that authority extends, to the way that you allocate your funding, to the way that you discipline your students, to several different areas. And it's a strong argument for the districts, but not a insurmountable one.
Right, and that obviously cuts both ways in terms of what they want to enforce or not enforce. So.
Absolutely, and then that would make them responsible.
I did want to open the floor to if you guys wanted to bring up anything in particular that is on the horizon.
The only thing I talked about was the vouchers, the school vouchers law that was passed, and I haven't read about it since it was passed. But that's one of the things I think when you're talking about the educational civil rights of students, there's an issue there that I think we should look into, which is the taking of public money and putting it into schools that may be proselytizing, that may be religious schools, that may be establishing a certain religion or imposing the limitation of the free exercise of somebody else's religion. So, which is part of our First Amendment jurisprudence, and so that's a new thing. Not entirely new. Vouchers were tested at the Supreme Court and held to be constitutional. A voucher system out of Ohio, and I think that was 10 years ago. Mm-hmm. So there is authority that supports the idea that vouchers are a constitutional exercise by a state. But I'm concerned, and I think that's one of the things that we're going to see on the horizon. You think?
Yeah, I do. And there's a even more recent Maine case from the Supreme Court that gives not necessarily a green light to all voucher programs, but makes a challenge to them more difficult. I think we're also going to continue to see, because we have seen already attacks on free speech at the university level. Some of that through state legislation, and there is legislation that passed several years ago in Georgia, especially around inviting guest speakers, those sorts of issues, and protests by students. So that's going to be a continuing issue. Kind of at bottom, the ultimate role of education is in question in all of these areas. One of the pieces of legislation that survived one body in Georgia this year but did not survive another was up until the last minute part of a combined bill that would have prevented any role for the American Library Association in students' education. In terms of selecting books, recommendations for books, any of that would have been prohibited under that law. So we'll see more of it. It's a political football that they will keep trying to run up the field as long as they can. And if they see election results that are not favorable, then they may take the ball off the field. But right now, I think, and it largely started when Glenn Youngkin, who was the governor of Virginia now, ran on this plank. This was his primary plank. And, it's not surprising that when he won in a very kind of swing state, then states across the country began to look at these kinds of statements, essentially political statements that have real life consequences for students, real life consequences for families, and ultimately for all of us. We don't have kids that are prepared to walk out of the door at the end of high school or college, ready to take on the world.
And I know I said that was kind of like my last question, but I guess I lied. It keeps spawning new questions for me. But as we kind of look at how the school boards kind of approach things, and we kind of see how, favor for topics versus disfavor for topics kind of develop, do you think there's any kind of evidence that I guess these different school boards or like on a statewide level that will be particularly useful for organizations looking to like litigate these issues?
I'm not sure I'm following your question, but I mean, what I would say is that the diversity of interpretations of these laws demonstrates their vagueness. If, a school board out in the middle of wherever has one interpretation that's dramatically different than a school board, elsewhere, that demonstrates the vagueness. And then, you're taught from the first day of law school, good facts make good law, bad facts make bad law. And for us, bad facts, meaning awful things that happen, if you're a civil rights lawyer, awful things that happen make for good cases because they demonstrate the problem. And so we are already seeing it. Cobb County is a good example of it, but there's elsewhere across the state these situations where the law is taken to an extreme law is taken to an extreme, and that creates a fact pattern that judges will hear.
Yeah. And you actually, you did answer the question. I was kind of, I guess it was a little cryptic, but in terms of kind of like data and like statistics of, teacher complaints, student complaints, kind of parent complaints, things like that. I was just kind of curious, like if that was the kind of evidence that might be useful as it kind of develops and people get more of a record of that. But I mean, you kind of answered that. So,
Yep.
Okay. So with that, I want to thank you both for letting me pick your brains about this important topic. And you both just have such a tremendous amount of knowledge in the First Amendment and just experience. So I really thank you guys for being here. And with that being said, 1Ls, 2Ls, part-timers, I really cannot recommend this class enough. You'll be surprised just how much your daily lives depend on First Amendment protections. And with that, thank you again, American Constitution Society, for hosting this podcast. And finally, to our listeners, thank you so much for tuning in.
Thank you, Cody.
Thank you.